All right, good evening. Let's call to order the regular meeting of the South Orange Historic Preservation Commission. First off, we'll have our roll call. Kathy?
Yes, Chairman Hill,
Present.
Commissioner Langzum,
Present.
Commissioner Marlowe,
Here.
Commissioner Don,
Present.
Commissioner Carter,
Here.
Alternate Commissioner Moan,
Here.
and Council Sullivan.
Here.
Not in attendance is Trustee Steve Schnall and Vice Chairman Bob Barnett.
Noted. Okay, meeting of this notice. Adequate notice of this meeting had been provided to the press in accordance with the Open Public Meeting Act, NJSA 10-4-6. In addition, notice of this meeting was posted in Village Hall and on the village website and has been filed in the office of the village clerk. Official action may be taken. All right, with that, first topic of discussion, approval of minutes. Has everyone had a chance to read the minutes?
Yes.
Yes?
Yes.
Any comments, changes that we need to be made?
Nope.
No.
Good? Motion done?
Good.
Everyone's, all right, I need a motion to approve minutes.
Motion to approve minutes of November 18th, 2013.
I'll second.
Second, all in favor?
Aye.
Aye.
Any nays? All right, minutes approved. All right, then we're going to continue with case number 2013-2, 14 Kingman Road. Good evening. Can you give us your name for the record, please?
Hendrick Richardson, attorney for Hazel and Luther Turner. The application is regarding 14 Kingman Road.
Thank you for coming by tonight. I know we've got the deed in front of us now. And to say the least, the original deed is handwritten and a little legible,
Right.
but has everyone had a chance to give it a glance and take a look?
I've only just received it a few minutes ago, so I have not been able to read it.
Okay, I can summarize it. The first deed is illegible, but from looking through the deeds, it is presumed to have been dated in 1908. I think the purpose of us coming back was to submit a title search of the property, specifically looking for any deed restrictions. So the first deed, unfortunately, we can't read it. I did request from the title company if there was any way to get it more legible. I have not heard back from them. The subsequent deeds dated April 8, 1956, and the succeeding two deeds do not indicate a deed restriction. It seems that the third deed held by New Jersey Improvement Company let the property lay fallow for almost 31 years, and I'm just putting that on the record. And then within 2 months of acquiring the property, they conveyed the properties to my client in 1987. But again, if you look at all the three deeds subsequent to the first one, the descriptions are all the same, and there's no reference to a deed restriction. And also, just for the record, it's my understanding that deed restrictions, that the Central Planning Board are not limited to any deed restrictions, if in fact there is one, that they can consider it, but it's not something that they would then be able to deny my client's application.
I'm sorry, I couldn't hear what you said.
According to zoning law, with regard to restrictive covenants and deeds, while the Central Planning Board might review it, they cannot deny an application based on deed restrictions. And assuming there is one with regard to this property, but when I go before the Central Planning Board, I'm going to make that, make them aware of that. Like a deed restriction doesn't stop the show, so to speak. And there's several case laws on that.
Okay, so at this moment, I'll open it up to anyone who has any questions about the deed, or what they saw or read.
No.
I know you
My
haven't
main
had-
question, I just can't read it.
You can't
I mean,
read it?
the rest-
The rest is pretty straightforward. I've read enough of these, but I can't read the first
The
one.
first one is, yeah, you can't even,
Yeah, I think we need to see a legible copy of the original deed.
I would suggest maybe a photograph, because then it can be
We
blown
had a
up.
title search do this. I didn't personally go do this. And again, I did ask the title company to go back and see if they could provide a more legible version of this. And again, I haven't heard back as to their ability to do that.
I have a procedural question.
sure.
Would the later deeds supplant the previous deeds?
Defer to council.
Sometimes restrictions that are in earlier title documents don't end up getting reflected in the later documents, sometimes by mistake, sometimes intentionally. That's why they have you go back in the chain of title. In this case, because of the unique situation here with the original restrictions on the properties, that's why I think that the mandate is to go back to as far as you can go. Yeah, I guess the issue for the commission is that the applicant has gone back and tried to find the information that they can find. Unfortunately, the copy, the oldest one, is not legible. I think the burden on the applicant is to make a good faith effort to find the information, and your issue is whether or not there are any restrictions that apply. If there don't appear to be any restrictions, then I think you've addressed the issue.
And again, I want to restate that even if there was a restriction as to the lot size, that's not a consideration for the Central Planning Board. They cannot deny an application based on any deed restrictions.
Well,
I mean, they can certainly consider it, but it's not a basis for denial.
let me say this, Council. I think that I'm aware of the planning board cases. I'm aware of the impact of restrictive covenants. Usually a lot of those came up in a constitutional context. I'm not sure whether that's the situation here or not. And the issue of the effectiveness of those covenants is an unresolved issue in South Orange. It's the subject of now stayed litigation. And so I think that it is an important issue to the commission. And so in this sense, I think it's, in my view anyway, it's irrelevant whether it's enforceable or not, because I think you've produced documents that, to the extent we can tell, don't seem to include it. But I don't want the record to reflect that I agree with your assessment that it's not valid at all for them to consider.
Okay.
The reason I believe we need a legible copy is that many times, or in my own research, when I've looked at properties, in fact, when I researched my own home, the covenants were in the original deed. And these deed books are very large documents, and this is a photocopy that's been shrunk to a page that's 8 by 11. So I think you need to ask the company to either, as Ms. Marlowe suggested, take a photograph of the document so that it's legible, or copy it at its original size, or it can actually be enlarged in order to see the actual text. And the covenants didn't necessarily have to do with lot size. Some of them had to do, I'm saying in general in Montrose Park, they had to do with setbacks. They had to do with whether one property could be used. There were restrictions about whether you could have a hat factory on your property, or whether you could have a piggery or a hennery, and some of those things that we might think are outdated today. But other things in terms of what could be built on that house specifically were often in there, and sometimes there were words that said something like, "and this runs with the land." So I think that's the kind of information that the commission is looking for, to see what was actually written in this original deed.
Okay, well, we can certainly try to do that, but this is costing my client significant money for a which is in fact a minor subdivision. And, she's paying two bills, one to the Historical Preservation Committee and one to the Central Planning Board, and it's becoming quite expensive, so we'll certainly look into doing that. I don't think we need another hearing on this. I don't know if we need to adjourn, or do I just, if we submit it to the commission for their review? Because at some point, you're making a report to the Central Planning Board, I presume.
I guess I have maybe two thoughts on that. One option is you could say, we don't want to make a decision until we know what's in the deed, and ask council to go back and make a good faith effort to try to obtain a more legible deed. The other thing, and it's not unusual in the land use cases, is that if you were satisfied with the application and all other aspects except this issue, you could give an approval to the certificate conditioned upon within 30 days or whatever, the applicant coming forward with a more legible document. And if that more legible document indicates that there is any covenant or restriction, then you would hold off on your report and not, we'd have to come back and revisit the issue. So I think the problem with is either way, I don't see how you're going ahead to the planning board, because what if the board approves it conditioned upon you're producing a more legible copy, you go to the planning board and then you find another copy and it has a covenant in it, then the planning board is acting, but it hasn't satisfied our condition.
Mm-hmm.
I'd like to try to accommodate you that way, but I don't know how you would go. Usually we don't have to go to two boards, that's what's unusual about this, right? Usually if you're in front of the planning board or the zoning board and you have an outstanding issue like the board wants a better landscaping plan, right? And so you condition the approval based upon submission of a landscaping plan that's satisfactory to the municipal engineer. Well, that's fine. And everybody just waits and nobody builds their project until this engineer's satisfied with the landscaping plan. Here, the problem is that another board is going to take jurisdiction and move forward, and there's the possibility that the document could come back and would be unsatisfactory to this board. So I'm not sure it helps you either way.
Okay, well, it's my understanding that this particular board, the Historical Preservation Committee, is advisory to the Central Planning Board, correct?
No, in
Am I
this case, no, in this case, the ordinance for subdivisions, it requires a certificate of appropriateness from the board. So there's actual official action that's required by the board as opposed to advice.
And it's still advisory to the Central Planning Board, though.
Well, the way I read the ordinance, you can't go ahead with the subdivision without a certificate from this board. That's the way I read it.
Okay, that's not how I read it. That's not how I read it, but I just wanted the clarification. Okay.
So my recommendation would be, as much as I would like to recommend accommodating them, I don't see how you can do that in this particular case, because you've got another board that is waiting on your decision, and you can't finally make your decision until you have another copy. Unless the majority of the commission disagrees with Commissioner Don and thinks that you can act based upon the copy that's in front of you. That's up to you.
Okay, let's, opinions? Start over there.
Are you asking me, am I
Yes.
in favor of?
Yeah.
I am in favor of waiting for a legible original deed before we provide.
Commissioner Carr?
I agree. I'd like to see a more legible one. I also wondered if this was faxed over, or was it actually
No, this was
Sent in
emailed to me from my
emailed?
title company.
Okay. So, yeah, I would prefer to see a better copy of it.
Commissioner Lang?
I concur with Commissioner Don and everybody else's recommendation. Some of these older deeds have covenants in them that would directly affect our decision.
Okay. I know.
Yeah, I concur, too. I suspect, I can't read much of it.
Neither
But-
can I, so.
I don't think there is one, but I really would like to see it. To be sure, I don't want to make a bad decision. I want to make a decision based on all the evidence.
I'd also like to make a request that if we could have this information a few days ahead, that we would have time to read it?
Well, I was hoping to get a more legible copy prior to today, because I've had it for about a week. And I had asked, a couple of times what was going on, but they just couldn't produce it.
Well, I guess this might have been avoided if you had communicated that to us, because we might have been able to give you some suggestions.
But,
So you're going to motion carry.
So the recommendation then is that you need to see a legible deed presented. Now, procedurally, can that just be submitted if we do go forward with obtaining one? Or do we have to come back before this board or the
I understand
commission?
the question.
Procedurally, do we need to provide, can we provide a more legible copy of the deed, if that's what my client intends to do, directly to either to Ms. Cameron or Mr. Hill, or do we need to come back?
No, you need to come back.
Oh, okay.
Yeah, you're going to have to come back, because that is one of several considerations that the commission has to make in order to determine whether they're going to issue the certificate.
Okay.
Need a motion to table this till January?
Well, before we table this to January, procedurally, does the applicant have to agree to allow us to now carry this forward?
Yes.
Because if they don't agree to let us carry this forward, then we're going to have to make a vote on the information that we have here.
That's true. Right. So you'll consent to the adjournment of
Yes.
the automatic deadlines, right?
Yes,
Okay.
and then I'll advise the commission how we're going to proceed.
Right. And then you and I'll need to speak to Patrick about the...
Well, yeah, I've
the
been
planning board.
I've been trying to communicate with his office. I don't know if they set their dates yet, because I haven't gotten a call back.
Okay, okay.
All right?
Right.
Okay, thank you.
Thank you for your
Thank
time.
you.
Okay.
So,
Yeah. Do we have to,
Motion?
motion to carry it over?
motion to carry.
Motion to carry.
I need a motion to carry
Motion to carry,
case number 2013-02, 14 Kingman Road.
over to the next meeting?
The January meeting date, which I don't think has been set yet.
Nope. we're
No,
good.
to the next January meeting date, whatever that may be.
So, we have a motion?
I have a motion. I
We have
made
a
the
motion to
motion.
carry?
I'll second.
Second, all in favor? Aye. No nays? All right. Motion carried then to our January meeting. We're
We
gonna
haven't-
Give us 5
Give us
minutes.
That's
fi-
next.
We're gonna get there.
Give us 5 minutes.
You can have this.
Resolution, here we go. Next on the agenda, there's no new business, so next is Resolution 2013-005, resolution approving the 2014 annual meeting schedule for the Township of South Orange Village HPC Commission, or Historic Preservation Commission. We all have copies in front of us, we all saw that. So, as we look.
I have a question as to,
Sure, question.
is it because of the renovations that are going on that we moved from Wednesdays still to Monday, Tuesdays?
Correct. And it's also a part of the availability of the SOPAC facility. So there's the renovations, there's the availability, so it kind of bounces around between Tuesdays and Mondays.
And then when are they going to settle the rest of the year?
At the moment, the way the SOPAC's annual calendar is based, it goes through May. So then they renew their schedule, so we'll know more once they do that. Once they have their schedule, we'll know the availability of this, because I don't know how long the renovations are going to continue on past that. That's probably
We're there for 2 years.
2 years, so there you go. So it's just a matter of them deciding their schedule, and then we can do that in May, at the May's meeting. So if everyone
Hopefully within
has a
6
chance to
weeks.
look at this, any other questions regarding?
I believe none of these dates have changed from previous dates that we were given.
That-
I'm checking that right
I
now.
don't believe they have.
They
I
have.
think that they're what we had tentatively seen.
Right.
Yeah,
Mhm.
those are all tentative.
Okay, if there's
Because I
no-
remember specifically
They're the
the
same.
last 3 dates. It was St. Patrick's Day, my nephew's birthday, and my birthday.
Well, I just
So it's
checked
just
my-
easy, those, you know.
Personally, I
dates.
object to St. Patrick's Day, but that's
St.
okay.
I
Patrick's
just
Day.
I'll make
checked
the
my
sacrifice.
calendar, and they are all the same as what we had
Yes.
previously been given.
Do we get
I
clean
thought
beer?
they were final last time, so I
Irish
marked
soda
my
bread after.
calendar.
I'll bring soda bread.
Pencil, always in pencil.
This is for the purpose of noticing.
Yes,
Because this
yeah,
will,
yeah.
this will take public notice.
I would just say if we could just correct the spelling on resolved and be it further resolved.
It's
Duly
reload
noted.
twice, 3 times, 4 times.
Yeah, otherwise
Oh,
it
I
takes
like
us
that
fine.
spelling.
I think it's a good way to spell it.
Sure.
Okay, so with corrections, do I have a motion to accept the meeting dates for the HPC?
I'll make a motion for that.
I'll second it.
All in favor? Aye. Any nays? No, then motion carried. We have accepted the schedule.
January 21st.
January 21st
Yes,
is
at
the next
7:30.
meeting.
I told you it's about 5 minutes.
Was, it's not down on the bottom. Did you want to make a public comment? We'll accommodate you now if you. Sure. All right, so,
Well, hang on,
one second.
If it's on that pending application, they shouldn't do it until the bottom.
Are you going to make it about the pending application that we just tabled, or did you have a comment to the board? Pending application. Then we can't do it without their,
Yeah.
sorry.
Okay, good.
Okay, thank you.
No,
Be on your way.
okay, so
I just procedurally, should we have held comment on that application while they
Since
were
we
here?
tabled it?
I mean, should
The-
we
The
have?
the way that, yeah, well, yeah, the way that, again, following the land use model, the way that it usually works is that if the applicant has witnesses, then some boards allow members of the public to ask questions of individual witnesses. And then whether or not you do that, then after the applicant has finished their case,
Okay,
then the public has an opportunity to come up and speak.
okay, so the case was not finished?
case isn't finished yet.
Okay, gotcha. Thank you.
all right. So-
I don't know if this is appropriate or not, but can affected properties that are adjacent to property.
Hold on.
Wait,
You have
Can I
to
be on the
you have to
microphone?
come up,
and-
Sorry.
and you also have to give your name for the record.
Yes.
And
Good
address.
afternoon, ladies and gentlemen of the commission. My name is Jeremiah O'Leary, and I am a resident of 18 Kingman Road in South Orange. We are the property that is immediately adjacent to the property located at 14 Kingman Road.
Okay.
And my question, directed actually to council, but to the commission in general, was whether it was appropriate or whether we as a property owner would have standing to retain counsel to challenge some or all the aspects of this application.
Certainly. Certainly. Again, just maybe to supplement what I said before, if someone appears as an objector, and we have experience with that here on the one and only application that this commission has considered, that...
And various other commissions of
that
South Orange.
That the objectors can retain counsel, and then the way that it usually works is that after the applicant finishes their case, then the objectors can put on a case in chief if they want to. They can bring witnesses, and certainly their counsel can cross-examine the witnesses of the applicant.
Thank you. One other question in regard to notice. Is there a notice requirement relative to properties within a certain geographical location of the property for which the application is being sought before this committee? I know there is before the planning board,
Yeah.
but we received no notice, at least to our knowledge, of this particular application. Not this meeting, but this application.
I think the answer to that, unfortunately, is it's unclear from the ordinance whether notice is required or not. I will tell you that that for demolitions, a document that was adopted by the board and is in use now does have it in a checklist item for notice. We don't have a formal application yet for a subdivision application. So there was nothing that was provided to the applicant that told them that they had to notice anyone, and so they didn't.
Well, procedurally, there has been no submission of a application for
There's an
subdivision?
application, that just that the application form, which they had to fill out, didn't say, oh, by the way, you have to notice everybody within 200 feet. And the ordinance that we're going on, you have to understand, this is a new commission, a new ordinance, a new
Understood
process.
completely, Counsel.
Everybody's
Yeah.
just trying to figure out exactly
Sure.
what they're supposed to do. There's nothing in the ordinance that says for a subdivision application, you should notice everybody within 200 feet. So the answer to your question is, there's nothing in writing that says they had to notice, and they certainly weren't told they had to notice. So they didn't notice.
May I ask a question?
Yes.
Did you receive notice from the planning, of the planning board application?
We received no notice whatsoever.
Well, that's a different question. And that you need to take up with the planning board, because clearly as the property owner next door, you were entitled to notice of the subdivision application of the planning.
Oh, that's precisely what I'm talking about.
Well, I can't answer for the planning.
That's a
I thought
only
the
answer for the
application was
board
made
I
in the first
represent.
instance to this committee, not to the planning board.
I'm sorry?
I thought the application for the subdivision was made in the first instance to this committee as a procedural matter, not the planning board.
I don't know the
No.
order that they filed them. I can't answer that.
Okay.
Well, the planning board did review it.
You would have to go first to the planning
They
board.
did review it.
And then they
With
sent it.
And
Yeah.
Susan Gruhl issued the report that
Okay.
for completeness, it was complete.
Yeah, that's
as
right.
far-
I'm sorry, I was wrong about that. Yeah, it has to go to planning board first, because the planning board has to deem it complete before they send it here.
Right,
So-
and
so
we received
there
no
is a-
notice of
There is
that,
a
that's
planning
why.
board application, and now, I would just speculate, which I should do, is that if there hasn't been a meeting date set for the planning board for this application yet, then they wouldn't have noticed you, because they don't know what the date is to notice you for. All right? So that may be the answer to the question, but I couldn't say that.
But they're not
We
going to
did-
set a
we did
meeting
re-
until after this committee has submitted its certificate of appropriateness.
I
would
was under
assume.
the impression that they were trying, and I don't know what happened with this, I understand, they were trying to set up a meeting schedule where they heard us tonight and the planning board heard them on Wednesday. But maybe that didn't happen, I don't know. And obviously, you should
We'll
find
follow
out.
up with the
And when I
planning
have-
board.
When I have a discussion, when I mentioned before to council that she and I and Pat Dwyer have to have a conversation tomorrow, because my understanding of the way this was going to work was that they would not go ahead and have a meeting until after we had made a decision.
Thank you.
I believe we had a list from the planning board of the addresses that were noticed.
Yeah,
Yeah, it's
I
here.
think that the list,
Is it in
in
there?
looking
Yeah,
at this,
hold-
I think the list was proposed.
have that list here.
A
Hold on.
proposed list for publication by
Somewhere it's in here.
the applicant
Just had it
prior
in my hand a minute
to
ago.
the hearing before the
Here.
planning board.
13,
If you look at it, it wasn't published, it
O'Leary,
was a
Jeremiah, and
proposed list for
Well,
publication.
yeah, I can explain it. What you're looking at in your package is a part of the application that they file. And what happens when you file an application for any land use application is that you write to the tax assessor and you ask for a list of all properties within 200 feet.
Right.
They give you the list and then you include it in your package. That
Yeah.
doesn't mean they've been noticed, it just means that that's what they have
But if
to
you look
do.
at this, I think some of the confusion is that included in here is the affidavit of service and publication, but
Mm.
it does not appear to have actually been executed.
Oh, well, right, yeah, that's
it's
because,
just a
no,
draft.
and that's
That's a
because in
draft.
some towns, and I guess South Orange is one of them, make sure the applicant shows the forms that they're going to use when
Right.
they actually
That's
notice.
what I
Because they
believe.
want to know that they're sending out the right notice.
I thought, until just now, I thought it was published
Right,
as well.
No.
because, you
Yeah.
see, the notice
I-
in the
My
paper.
guess is that you haven't gotten one yet because they haven't sent them out yet. That's my guess.
But
Right.
counsel, I'm confused, because if this was heard in front of the planning board in discussion
Only for completeness.
for completeness,
Right.
isn't that
They don't have to
public-
notice for completeness.
Oh, so you don't have to notice for completeness?
Right.
Ah, okay. Thank you.
Right. This is no
Thank you.
dates on any of these affidavits of service or
Yeah,
anything.
that's why. They just want to see the form first.
Okay. Okay, so we passed resolution of meetings.
Yes.
Okay, discussion topics. First off, we have a proposed cell tower letter from Cardno ATC. Council, I'm going to direct this one to you.
Yeah, just really briefly, I think we'll get these kinds of letters once in a while. When you are doing a project that requires federal agency approval of many different kinds, that triggers a Section 106 review under the National Historic Preservation Act. And these are basically form letters that they have to send out in order to demonstrate compliance with what Section 106, and also, in some cases, the state, the SHPO office. I've looked at this, it doesn't seem to me we have any jurisdiction over an antenna on a telephone pole. I don't think that falls into any category that we can think of. As a matter of fact, and more importantly, I guess, they don't need land use approval. Local land use approval is preempted under the Federal Telecommunications Act. So I don't think they really need to, we don't have any jurisdiction, and the planning board doesn't either.
Basically, just on the list that gets the copy of the letter, but everybody else.
Yeah, I mean, well, you could, if you felt it was important to do so, you could write a letter with comments on it that would be part of the application, like anybody other member of the public filing comments on the application. If you felt that there was something you wanted to say about this, we could write a letter and it would be submitted as part of their application file. But you don't have a right to say yes or no.
Do you understand, is this 39.5 feet in addition to the 34 foot?
No,
It's 39 feet total?
total. It's installation of telecommunications antenna at a top height of 39
Okay,
and a
that's
half
what I just
feet.
wanted clarification on.
They are putting up a new 34-foot pole. 39 and a half feet is fairly tall, but as Bill said, I don't think we have.
I don't think we have any jurisdiction, but I know that there are neighbors who were very concerned about cell towers being erected in the historic district.
Right. And this was served on the Historic Preservation Commission.
So after listening to council here, we can make a decision to write a letter, but again, as far as I am relating this, we have no jurisdiction over it, other than we can say we highly disagree with this and give our advice to the company here and saying we disagree with this and you're disrupting the environment of our historic district, something to those notes. Is that something that the board here feels adamant about?
I think it's something we should consider,
Yes.
knowing how much opposition there is in the neighborhood, in particular on Terrell Avenue. I don't know if this is the same area of Grove Road near Terrell. I know that those residents have been very vocal, have been at many Board of Trustees meetings in opposition of this, and it is a concern to them.
Would we send it to even the Board of Trustees have no jurisdiction
No.
over this. So we'd have to actually send it to,
It's likely that they are required to keep comments and submit them to the FCC, something like that. But, filing comments there's no harm in it. I just don't know what good it'll do.
is that where Marshall School is?
Grove Road
Marshall
is on,
School.
Marshall School is on Grove
And
Road.
Terrell,
Terrell goes up and down to Scotland.
Scotland.
Goes
yeah, so it goes,
From-
It crosses.
Crosses, okay.
Crosses Grove
so
Road.
it's pretty much right, trying to think,
almost at the park.
right almost at Grove Park.
Yeah, the way this usually works, and Commissioner's well aware of this more than I am, but people in my office who do this stuff, I don't, that if you're putting these kinds of antennas or lines or things on existing poles, there really isn't any municipal review of it. If you are putting them you want to put a new pole up on municipal property or some installation on municipal property, then you have to get an agreement from the municipality to do that. But beyond that, there's really limited jurisdiction here. So your role, I think, as the commission is, if on behalf of citizens that are concerned about this, that you want the commission to write a letter and express concern about it, you can do that.
I do think that there is one issue, but it's not our issue, is the height, whether or not that is higher than what is allowed in the town. I don't know what the height is.
But it doesn't matter whether the height is allowed in the town or not, because we don't have jurisdiction over
Right,
something that's
well,
in the
that's
right
what
of
I
way.
said. I said, it's not entirely out of the scope of the village if the pole and the antenna itself is higher than, not our scope, but the scope of the village.
Even
There
if-
is a slight,
I don't think that the town has jurisdiction if they wanted to make it, I'm not saying they're going to, if they want to make it 50 feet.
well, I think they have, I'll give you an example. They were overridden, but in Ridgewood, they had a big argument about putting up the power poles there, which support the new Susquehanna grid. And the BPU overrode them, and then I believe the courts did as well. They upheld it because they're 50 foot tall, and Ridgewood has a certain character like South Orange, where it's a small village, And these are significant to the area.
This is a new
Chairman.
pole, and it is in, looks like it's in municipal right-of-way. So, sounds like maybe the trustees do have a right to say yes
Yeah,
or no.
I think it has to do with pole height and whether or not it's appropriate for the area.
Okay.
That's
the-
where they would have their jurisdiction.
Did the neighbors, people in the neighborhood, suggest an alternate location? I don't know how much wiggle room there is in how they've identified an exact spot, but something that's just outside of the
Well,
historic district?
I know I don't know if this is the same one, but there was an application that came up a while ago where they actually wanted to put one of these poles on somebody's property, which was still in the municipal right-of-way, because it's measured from the center of the road to a certain distance in, but it was on their front lawn. They wanted to put a pole. So that didn't happen. I think there was enough opposition to that that didn't happen.
But this is most likely in, almost all telephone poles in South Orange are in the rear yard. So there, I don't know if you knew that as our attorney.
No.
But there's,
Didn't know that.
it's very, very unique. They're not on the street. So there are certain right-of-ways or easements that the utility company has to come onto your property, but they have to notice you that they're doing it, I believe.
Okay.
Can I just
So-
clarify, are we talking about a 40-foot pole or a 73-foot pole? Because they seem to make a distinction between the antenna and the pole.
I'm having a little trouble.
It's a 4.5-foot pole, 4.5-foot antenna on top of a 35-foot pole.
Right.
It's actually a 34-foot tall pole.
34-foot pole.
5.5.
Right.
Right. So it seems to me we're going to end up with a tower that's 73 feet tall.
No.
Just 39.5 feet.
Right.
I don't recall
That's
the details. I know
not how it
neighbors were
reads.
concerned about the being very close to their bedrooms. At eye level, houses are, quite tall in Montrose Park. So,
It's just that they say they want to put an antenna of a height of 39.5 foot on top of a 34-foot pole. That
No.
sounds to me like it's doubled.
No.
Have the neighbors or the town written any letters in response to this letter?
These letters come all the time.
Okay.
I don't know. There is litigation between the village and, I don't know if it's Crown Castle or another. You'd have to speak with Mr. Roth or the village attorney in regard to that.
All right, first of all, we've mentioned there are people who are against this. Unfortunately, none of them are here tonight to give testimony to why or anything. I have,
The FCC does have a historic office, an office that reviews these things.
So-
And so it might be appropriate to send a letter, but I don't know what good it would do.
we could put this on, we could table this to next week's agenda, or next month's agenda. We can, if someone wants to write a letter, we can approve it at that time to say why we're opposed to such pole being in the historic district of height, or however we feel about it. Again, I'm just opening up more conversation, but if we want to do this, and we can invite the public to attend the meeting one more time to give testimony why it shouldn't be there. That's where I think we're at this moment.
Or why it should be, should or
Why,
shouldn't.
why it should be, or why it shouldn't be, yes. I have no, other than my personal opinion, it's, if someone wants to lead me down a path and give me their advice and why and how, I'll listen.
I'd be in favor of tabling it and trying to get some of the people who have spoken against or for it in the other, before other boards here to speak to us.
So I think we need to take a,
Well, I
Do
don't
we-
think it's our business to solicit people coming here to speak
Right.
to us, right?
I think the question here is, do we as a board want to write a letter to the Board of Trustees or to, because again, They're asking for
Well,
right-of-way, and if that's the case, from my understanding, then the Board of Trustees would have an
Well,
opinion on this.
I think one comment I would have is we would reach out to the Board of Trustees and find out if it's their opinion that they need actual to approve its location in the right-of-way, in which case then residents have that venue for comment. This letter, and I think this is typical, is that the comments are directed to the applicant. You can see that in the last paragraph, and they're required to then package all those comments and file them with the agency. That's the way it usually works.
Well, this
Okay.
was sent to the Township of South Orange Village. It wasn't
Right.
sent to this commission.
Right.
So who forwarded this to our commission?
I received it
It
in
was sent to the
mail.
attention
But
of the
you
village
received
clerk.
it, you received it as mail for the South Orange Historic Preservation Commission? And who was it sent to us by?
It was
There's
sent to the
there's nothing
township.
here that says it was, there's nothing here addressed to us.
Did the village clerk just, walk it over and hand it to you? Or?
No, no,
I mean, I don't see why we're getting this in,
okay.
I'm just curious. I don't see why we're getting this in, I
Well-
could see if we got this because it was passed on to us by another agency in the town.
Okay.
I just,
I can check with the acting clerk to be sure that she forwarded this on to the Board of Trustees Council, because that is the protocol when receiving letters such as this. I forwarded it to council and the commission because it was regarding the historical preservation, the section compliance that it was referencing, so it was more from an informative standpoint.
Is it possible Trustee Schnall could fill us in more on whether the trustees have actually
Would it be
discussed?
appropriate for me to contact Schnall about this? I will contact Trustee Schnall, find out. I will have Kathy email to everyone what the board is going to do about it. And other than that, then I think we should motion to table this
Right.
until next meeting.
I just wanted to add that a Section 106 compliance review is part of the federal government.
Right.
And so they're required, because they're doing this within a historic district, they are required to have this review. It's called a Section 106 review,
Yeah.
and that's by the federal government.
Yeah, the FCC undertakes that
Okay.
tower. They're-
It's because there's federal agency approval involved.
Right. So, but we are being noticed, whether we're being directly noticed because we are a historic commission in the town, or whether we got this because Ms. Smith saw historic preservation and said, well, we better give this to the commission, it's hard to know.
Sounds like the latter.
Yeah, that's what it
Right.
sounds like to me.
Right.
But it is appropriate for us to look at this, I think.
All right, so I will contact Trustee Schnall and find out what measures that the Board of Trustees are taking. I will relay that to Kathy to get it out to all of us. And for that sake, then, we need a motion to table this to the next meeting for an update and possible letter.
I move that we table this for the January meeting.
Second?
I'll second that.
All in favor?
Aye.
Aye.
Any nays or abstentions? Nope. Motion to table. Council's brought up one more thing to talk, that's not here on our meeting, but to talk about the Terrell Ave, the 333 Terrell Avenue application.
There was, well, it's an application to the construction official for building permit. And Kathy had forwarded it to me because, and I guess the way that I would describe it is this is maybe falls into the line of our all continuing to try to understand what our role is, okay? But this was a construction permit application for an addition at 333 Terrell Avenue. And the application has been reviewed by all the appropriate, people. It is an addition, and I reviewed the ordinance, and it came to the conclusion that additions do not require certificate of appropriateness, and because apparently, well, I don't know this for a fact. Let's assume that that this addition did not require site plan approval. Then it also doesn't give us the jurisdiction to review on an advisory basis.
And especially since it's not on the LLO, the local landmarks ordinance. If it were, wouldn't we have authority as a major?
If they don't need site plan approval, then we don't have an advisory role. If they don't need, there is no provision in the ordinance now that allows you to issue a certificate of appropriateness for an addition. It's demolition and subdivision.
And major facade.
And major facade.
But I thought that they could give it to us to review for comment or,
But, well, the point is, what I'm saying is, I'm operating the assumption that they didn't need planning board approval, right? If they needed planning board approval, then yes, then the planning board could refer it to us for a comment, right?
Okay.
All I've been given is the construction permit application. Either they didn't need a site plan approval, or they got it before we, were created. I can't answer that. But the other thing that I wasn't clear about that you could probably answer better than I was that Kathy's email said that it's on Terrell Avenue and it has properties bordering on land designated as historic. Isn't all of Terrell Avenue within the Montrose District?
yes.
Yes.
Right. So that's really not the issue. It is in the district. It's just that a standalone application for a construction permit, you don't have any authority under the ordinance. You don't have any jurisdiction.
Because it's being done as of right.
Right.
But if they already got a permit, then what can we do?
No, well, I guess what Kathy was asking me was whether this application should be considered by us. And
Doesn't seem like it's in our jurisdiction.
And I guess, well, I was just bringing it up for informational purposes because, yes, it's got approvals as recently as December 12th by the fire code official. So clearly, they didn't think you have any jurisdiction.
Or they didn't know about us?
And I think what it illustrates, again, is that we're all just still trying to get a handle on what it is that comes here and what doesn't come here.
Is the addition visible from the street?
Remember, right? Additions in the back.
It's in the back of the house.
It might be
Then I
slightly
think
visible from the street, I'm sure.
If it's not visible from the street, I don't think we have any say, right?
Yeah.
Yeah, here's the street, there's the porch, there's the addition.
That's one of the elements of the major facade, is visible from the street.
I just think that, no, I think if it's a major facade that's a historical facade, then we have the right to, we have jurisdiction over it. I think that if somebody has a house in a district and they would, let's say, add a garage onto the side of it, I don't even know if we have jurisdiction over
So
something like
major
that.
facade, as you understand it, means visible from the street.
That was my understanding.
Okay.
Right.
Okay. Good. Well,
But
that's
I think even in the historic district, it's only the specific key contributing properties
Okay.
that's on the local landmarks ordinance.
Okay, so that's that one. And, but that'll help me, I think, as we go along and, Kathy gets these in and she sends them to me, I'll have a better understanding where we are.
But if it is a major facade change and it's not on the local landmarks ordinance, we still can offer advice.
Right.
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 So just remember that.
Okay.
Okay, then. Continuing on discussions, new member application process. Update from Chairman Hill. Well, I was going to refer this over to Trustee Schnall because he sits on the board to approve our new member and at this time, so I'm going to table that discussion till he's present so we can have an active, open discussion about our needs and what they're looking for and vice versa. Changes to the village charter. That kind of comes under the village master plan, historic preservation plan element as well. So I'm going to jump down to the subcommittee updates to answer that question. How's that sound? All right. So topics, subcommittee updates, village master plan, the adding to the charter. We have met as a subcommittee And we've started, we have lots of reading material to read. We're looking at a plan that was done, Commissioner Don, what's the name of the plan? I have it right here. There was a plan done in July of 2009, Preserving Community Charter Recommendations for a Historic Commission, already done. So this is a 90-page document that we're going to read. We're also looking at to utilize sections of the Maplewood Historic Preservation portion, because we like how they've addressed it. So with the document that's already been done by the city, it was paid for by the city back in July of 2009, and plus what we're going to put together, we're going to formulate our addendum to the master plan of the city of South Orange. So we've got some work, but we've set a deadline. We're reading. We're going to all put in our 2 cents in the subcommittee, and then we're hoping to present at the April meeting our recommendations to go forward to the Board of Trustees. So that's our timeline that we've put together. Any questions about that?
I just wanted to say, actually, I think what you're talking about is changes to the village master plan, and the agenda says changes to the village charter.
You know what that is? I know what that is. I'm sorry. That was the vote to change the mayor to...
Right.
I'm confused. I apologize. So
Okay.
I'll jump back for a second.
Okay, great.
The Board of Trustees tabled that. They did not take a vote.
No, they did not. But they will at the December 23rd.
Yes. Thank you.
They are working on a revised proposal for the trustees to vote on, going forward with specific changes, but excluding possibly the titles of title changes, and also possibly excluding the stipends, because they had quite a few members in the audience, residents in the audience, who were opposed.
Yeah.
There you go.
Which is interesting, because I went back and looked at the election results, and it did pass. All of the changes did pass. It was a non-binding referendum, but the stipend, I think it was, passed by 25 votes. Not that there were many people that voted, but that was the margin of...
Right, but subsequent to that referendum, which is non-binding, then there was a very active Board of Trustees meetings where quite a few residents spoke out. And at that point, that's when the trustees did not move forward with the charter revisions at all. So this has been brought back again.
It sounds like it will be again.
Okay.
Right.
So, yeah.
And I think the changes, well, at least personally, I think the changes on compromise changes are fine. Changing it to Village of South Orange, or South Orange Village, whatever they want to call it.
Right.
And any of the other changes without the change to mayor and council. I support that ordinance, if that's what they agree.
I would too.
All right, so apologies. I got confused there for a moment. Any other questions about the changes to the charter? I think we've addressed that. And then we've addressed the village master plan
Well, are
subcommittee.
you going to present that to the rest of the commission in April?
In
or you-
April, we're going to present it here to the rest of
To the
everyone
commission.
on the commission. Subcommittee will put it out for discussion.
Can we get sort of like a rough draft
Absolutely.
Absolutely.
beforehand, so that we can, instead of having you finish this and then submit it to us, maybe we might want to put our 2 cents in?
Our goal would be to submit at least a rough draft the meeting prior.
That's
And then
fine.
bring it up for
No, good.
conversation again.
Now, just to ask our attorney, now, how does that work? If we have a proposed document, we can't, if we send it to our commissioners, can they provide comment, or is that then a discussion? And it's not about a case, so we could,
That's really informal. You can do that however you want.
okay, good. So we would be able to get feedback from other commissioners
Well,
and
just
then
like when
work.
we've done the other applications, you've sent the
Good.
document, everybody then
Good.
emailed
We
back
could do
to
that.
Kathy
Yep,
all of our comments, and then she can then formulate it and then put it into a, not saying that you guys aren't going to do a great job, but we just may,
we would want your input.
Absolutely. Everyone's input.
Good, good.
will have some input.
okay.
All right, so.
I'm sure it'll be perfect.
Yeah, it's going to be a long journey, that process, but because once we do that, we'll have to include the planner, everyone else for their 2 cents, and then present it to the Board of Trustees once that's all.
Doesn't it go to the planning board?
Planning board, the planner, planning board.
Okay.
And then from there, once they can say, yeah, it fits their requirements, then it will move on to vote for the trustees to mull over, and that could take,
Yeah, they would have to adopt it,
oh, yeah.
correct? Yes.
So
Okay.
it's a journey. We're all here together. So we'll update there.
Right. And I just wanted to add, Mr. Hill, you were correct. There was a 90-page document. This was a result of the study that the village trustees asked, and it was a multidisciplinary committee, members of across the town, and there was an RFP that the village put out, and various groups put in for it, and it was awarded to Higher Gruel, and they helped to facilitate public forums that were held, but they were charrettes, actually, several times throughout the community, and then this document was drafted, and it includes a lot of historic information. It includes a lot of information about proposed bulk lot requirement changes, and a lot of good ideas, so.
Yeah, so a lot of the heavy lifting's been done in this report for us. So it's a good jumping off point.
And it is available on the website right now.
That's what I was just going to say. I was looking over that this weekend, and it's still there.
It is there.
Subcommittee update, Pump House. I believe that's
That's me.
Commissioner Carter.
Okay, well, based on the meeting notes from November, I think Commissioner Barnett was going to talk to Trustee Clark. I don't know if he was able to communicate with him to just get an update of the status. In the meantime, I reached out to Janine Bauer because I know that she's been part of the River Greenway project, and I had some questions for her just to get a little sense of how much she was still involved, and if she could give me a status update. And what she wrote back to me was that Sal Renda would have the update, and I need to reach out to him. I just got this from her over the weekend. And I had gone through, and actually I had reviewed the original document, the proposal for the river development project that was done in 2005, I think it was. And I reviewed those plans. I reviewed them a couple of years ago for something else, but I went over them to see what the impact of, just what the plan was for the pump house originally. And in that document, the pump house was originally, the plan was for it to become somewhat of a nature center as part of the River Greenway development. So that was one of the things that I wanted to follow up with her, because I know that we've had some catastrophic flooding since that time, and that they probably had to rethink a little bit of that, plus the deterioration of that building. So she said it was not actually within the scope of the River Greenway group at any recent time to demolish the building, but Sal and the consulting engineer feel it is necessary because the building is dangerous as well as blighting, and because the connecting path to the new bridge, now that the new bridge, the pedestrian bridge that's going to connect the River Greenway back over to the other side, which is towards Walton Avenue and the Public Works area. The new bridge, they've changed the orientation of it, so the bridge will actually come right through the building now. And so that because Saul has decided to reorient the bridge in a different direction from the original plans from the consulting engineer. So I need to follow up with them. Obviously, it sounds like from this that the building is going to need to be demolished, or most of it's going to need to be demolished for safety issues. And now that the pedestrian bridge is going to go right through it, they're going to have to rethink what they can do with that area. So I'm just going to continue to follow up and see if I can get a little more clarification. In the meantime, I know we'd spoken about preserving some of the materials from the demolished building to see if we could use it to incorporate, to create some sort of signage that would memorialize the space, and one of the things that I had thought about in looking at the community was, I know that there is, the South Mountain Conservancy has developed this sculpture park up near the dog park in South Mountain Reservation. And so we do have a number of sculptors and artists in the community that perhaps we could call upon to advise us on ideas that they might be able to come up with for how we can incorporate materials into some sort of signage.
Cool. Good.
Okay.
Thank you.
Thank you for that update, Commissioner Carr. HPC website subcommittee update.
Oh, that's Commissioner.
Commissioner
Vice Chair.
Barnett is,
Vice Chair
Absent
Barnett.
today.
right, and I'm on that committee. We have
Me
not
too.
met.
We have
You have
not. As was reported last month, he did meet with President Torpy, and one of the issues is they don't have the new website up. They haven't told us what we're going to get, so it's kind of hard to.
We still don't have our documents up there either, I noticed.
On the current website?
I couldn't find our documents, the certificate of appropriateness and all that. I
I don't
couldn't
know if
get,
we requested to have those on the website.
I thought we had talked about that a while back.
They won't do anything now
'Cause
because
they're
they're
gonna get
waiting
the
to
new
move
website.
forward with the new
Okay.
website.
They're not, yeah, so we're sort of in a little bit of a limbo. 'Cause they
Okay.
won't,
And it is something, I think you're right, that we would like to have on
Yeah.
our web page, which we've been told we will have a web page.
Okay.
Yeah, because I went back to the link for the HPC that we looked at 8 months ago, and it was still the proposal to have a commission.
Yeah.
It was still up there.
Nothing's changed.
Okay. Thank you for the update. Procedures and checklists. Gone through the checklist.
Right, and one of the things actually that Commissioner Langston and I were talking about before the meeting is, and I think this discussion about the notice has now confirmed it, that we need to have an addendum for the other kinds of applications like we do for the demo. And so what I will do for the next meeting is prepare a draft addendum for subdivision and major facade. And we can take that checklist and duplicate it where appropriate and put it into each addendum form. And that way we can make sure that things like notice which are in the demo addendum, are in everything.
So use
I'll-
the demo addendum as a
use it
basis
as the
for the
base.
other two.
Right.
And I
Okay, so
think
I'll
I
take-
had emailed you the list of people. I had
Okay.
emailed you the notice list of what we had included for the demo addendum.
I-
All of the agencies
Oh.
and the neighbors, and I think that would be appropriate for
Okay. Right.
subdivision.
Okay,
No, I agree.
so I'll take care of that.
Okay.
Because that way the historic districts would know
Yeah,
about
if you
this
want,
as well.
Amy and I worked on the demolition addendum, so if you want to shoot us out some,
I'll prepare a draft and send it.
and then we can comment back if you want it, and since we're familiar with it already.
Right. Okay.
Yep.
All right, so with that, we've already kind of done public comments. I'm looking out the theater, I can see there are going to be no more public comments. So before I do a motion to adjourn, are there any other questions?
I have a question.
Yes.
There's been a lot of talk about, in different meetings I've been in with all of you, about our ordinance and what might be missing from it and what might be incomplete about it. And I just was wondering whether do we have plans to update or change that or fill in any holes we've identified?
Yes, this topic has been tossed around quite a bit. The ordinance itself is vague in some areas, and as a member of the subcommittee for the master plan, we're going to present as is, but we're hoping that once we get recognition in the master plan, then take the ordinance and go from there. But
Got it.
I think if my sense was right in our subcommittee, if we tried to change the ordinance before we got it into the master plan, it would probably be more difficult to get.
Yeah.
So based on what we have, we're going to go forward and do that. And then once we're established and part of the the whole master plan.
Okay.
Then we'll go back and attack
Thank
the
you.
ordinance.
I
It's
think
a-
we also have certain vagaries, I guess you could call them, in terms of like with this other application where we didn't ask for, a list of neighbors to be notified and things of that really need to be buttoned up now before I think we should button up what we have now within the ordinance that we have now, and then maybe look into how we might want to change it
I
in the
agree.
future. Because right now, we're sort of,
Yeah, we're not even
With-
really sure how the ordinance works.
right.
There's
so
no
once-
reason to change it before we figure it out 100%. Let's see how it works first.
But I think we can button up procedures, is what you're
Oh,
saying,
Yes.
right?
absolutely,
Right.
yes.
Right, in terms of what we are asking for when applicants
Well,
come to us.
right, there's certain procedures, and then, once we get that done, the master plan is sort of, the first phase of the master plan is in place, then we see what we have, and then we'll have seen a few applications, and we'll have gone through this a few times, and then we'll know what we think works well and what doesn't work well, and what we want to, at least we'll have some precedents and some, I guess, experience behind us to really determine, because I think any changes that we're going to make are going to have to go before town. So I think we just need a little bit more experience before we really want to do that.
Yeah, I agree. It's going to be like I said, a journey, and everything taken in the ordinance, we're going to button it up, get it done.
Once we've lived.
And when we
lived it a little.
get there, let's take care of this, what we have, and then, because with the master plan, we're going to designate other areas perhaps, we're going to do a lot more, and so we want to incorporate all those into it, and then go from there.
I had another question,
Sure.
and this is changing the topic, but we had talked about the old stone house previously, and we had been notified that it was going to be put up for sale. And I was at the trustees meeting when they opened it up for any public bids, and no bids were received. So I'm just wondering if we've heard anything further, what happens after that point?
Well, it depends what the city wants to do with it after that. As far as, if I read the ordinance, I would say that the city's setting it up for a presentation, because they're going through the motions of asking for bids, seeing if they're getting it, so that they can present their case to us. That would be my opinion about what the city's going through, because they have this ordinance now, and the ordinance reads, got to put it up, show due diligence that you made efforts to sell it. And then what they decide to do with it, and I don't know, I'm not a mind reader, but again, in my opinion, I think that they're going through the processes of seeing what they could do with it, demolish it.
Since I've lived in town 19 years, and I would say 18 and a half years ago already, I've walked through this old stone house with different, and over the years, it's just been different groups that have tried to bring that back to life. And it's just...
Has there ever been a discussion about relocating it and reconstructing it on a different site?
One of the biggest problems with the old stone house is that there have been so many additions to it over the years that it was very difficult to get anybody to agree as to what should constitute the old stone house.
Yes, right.
The old stone, the house itself is teeny.
Right.
And then over the years, and there was talk of it being a museum. At one point, there was talk of it being changed into overflow for the police department. It was just a whole bunch of different things were thrown out there. But the cost to stabilize it and to maintain it, there was just never any money for it.
Well, they did get a sizable grant to stabilize
To
it,
stabilize.
which they would have to pay back if
Right.
they went through with trying to
And then
demolish
at one point,
and as well as doing the archaeological
right, so I think
dig and
it's,
demolition itself.
Right, there was a whole study of it. I think you were part of that study.
There was more than one, but yes, the last
Right.
one, yeah.
Right, so I guess, are they going to move forward with demolishing? Is that what they
I-
want? But they have a lot of things they have to do in regard to
Oh, yeah,
that.
well, first thing they have to do is go to SHPO.
Right.
And what SHPO says is that just because the building is in disrepair does not mean that it's eligible to be
Delisted.
delisted. That's not a designation. You cannot say, well, it's in bad shape, so we want to delist it and demolish it. No, you listed it so you could get money to repair it, and now you want to delist it? It just doesn't work, especially on a public property. It's much easier if it's a private property. But once you have a public property that's designated as a historic site, it's very difficult to delist it and demolish it. I mean, there are obviously issues with the old stone house. Probably one of the, aside from the house itself, is the property. It's landlocked. And they won't allow a flag lot, and yet they've done nothing to provide egress to the building. Although they did talk about it. They talked about taking a portion of the police station driveway and making a street, because they wouldn't approve anything. It'd have to be a street, a designated street that went there, not just a driveway.
I'm at a quandary just because I live on that property lot. So
Yes.
I have all sorts of thoughts about it, but I'll just refrain at the moment.
Okay. Well, I just thought I'd ask to see if we'd heard
There were-
anything.
I haven't heard anything.
There were other great buildings in town that, even though they're being used, are really being neglected as well, and, so it's where do you start and where do you, it's really just, where's the money coming from to do all these things? That's a really major concern. I'm sure if somebody came up with $1 million to fix that house, everybody would jump on the bandwagon in about 15 seconds, but
It probably takes a lot more than 1 million to
Yeah.
fix that house, so.
you strip off all the additions, you come back to
Right.
the old stone
I like
house.
Your
that you could do for $1
your
million.
idea, Commissioner Dunn, to just strip it down to what was the original.
Well, that was something I had thought of years ago. Why not strip it down just to the stone house and have some plaques that
marker.
memorialize the different additions and just leave it as a historic site? But
All right.
anyway.
Any other
But we may
questions?
be discussing this in detail.
We may be. You never know.
Should we take
Okay.
it on as our pet project?
No.
I don't think so.
We have plenty of projects.
We've got plenty of, we've
All
got
right.
plenty of
Any other questions, topics,
projects.
concerns before I move for motion to adjourn?
I make a motion to adjourn.
All right. So motion to adjourn.
Second.
Got
Second.
one second? Second.
Second.
All in favor?
Aye.
Meeting adjourned.
Thank you.
Thank you.